4-1-5-2, People versus Theodore, Wafer. This matter is before the court for a jury trial in progress.
Good morning, Your Honor. Danielle Hageman Clark on behalf of the people.
Good morning, Your Honor. Terry Anderson, appearing on behalf of the people.
Good morning, Your Honor. Cheryl Carpenter on behalf of Mr. Wafer is standing to my left.
And Matt Carpenter from Mr. Wafer.
Okay, good morning. Anything we need to put on the record before we bring in the jury?
Not at this point, the people.
No, Your Honor.
Okay, bring them in.
All rise for the jury.
Jury, please go on and take your time.
You may be seated.
Good morning, everyone. Good morning. I'm not trying to chastise any of you because I really do appreciate your service, but if you're late, these are all the people you keep waiting. We can't start without you. So please be on time. We're going to start at 9 a.m. every morning. Please be on time. Ladies and gentlemen of the jury, you've been chosen to decide a criminal charge made by the state of Michigan against one of your fellow citizens. I'm now going to ask you to stand and swear to perform your duty to try the case justly and to reach a true verdict. If your religious beliefs do not permit you to take an oath, you may instead affirm to try the case justly and reach a true verdict. Please stand and raise your right hand.
Each of you, do you solemnly swear or affirm that in this action now before the court, you will justly decide the questions submitted to you, that unless you are discharged by the court from further deliberation, you will render a true verdict, and you will render your verdict only on the evidence introduced and according with the instructions of this court, so help you God.
Okay, you can be seated. Now I'm going to explain some of the legal principles you will need to know in the procedure that we will follow in this trial. The trial follows this procedure. First, the prosecutor is going to make an opening statement where she gives her theory about the case. The defendant's lawyer does not have to make an opening statement, but she may make an opening statement after the prosecutor makes hers, or she can wait until later. The statements are not evidence. They're only meant to help you understand how each side views the case. To prove the charges, the prosecutor must prove the following beyond a reasonable doubt. In count 1, the defendant is charged with the crime of second-degree murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Renisha McBride, that is, that Renisha McBride died as a result of gunshot wounds. Second, that at the time of the killing, the defendant had one of these three states of mind. He intended to kill, or he intended to do great bodily harm, or he knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of his action. In count 2, the defendant is charged with the crime of voluntary manslaughter, Counsel, can you approach?
Sorry, I just wanted to make sure.
Yeah, right in. Oh, no, why is that? All right, my apologies, ladies and gentlemen. In count 2, the defendant is charged with the crime of involuntary manslaughter. With this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Renisha McBride. That is, Renisha McBride died as a result of gunshot wounds. Second, the death resulted from the discharge of a firearm. Third, at the time the firearm went off, the defendant was pointing it at Renisha McBride. Fourth, at the time the defendant intended to point the firearm at Renisha McBride. And fifth, the defendant caused the death without lawful excuse or justification. In count 3, the defendant is charged with the crime of possessing a firearm at the time he committed a felony. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant committed the crime of murder or manslaughter. Those crimes have just been defined for you. It is not necessary, however, that the defendant be convicted of those crimes. And second, that at the time the defendant committed the crime, he knowingly carried or possessed a firearm. Now next, the prosecutor is going to present her evidence. She may call witnesses to testify, and she may show you exhibits like documents or objects. The defendant's lawyer has the right to cross-examine the prosecutor's witnesses. During the trial and during the opening statements, they're going to be showing exhibits on there. For any of our jurors, I reserved I call it the space for the second jury. You can sit in any of those seats if you're having a hard time seeing the screen. So those seats are reserved for you to move around so that you can see the evidence being presented. After the prosecutor has presented all her evidence, the defendant's attorney may also offer evidence, but does not have to. By law, the defendant does not have to prove his innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor and the defendant's lawyer will make their closing arguments. Like the opening statements, those are not evidence. They are only meant to help you understand the evidence and the way each side views the case. You must base your verdict only on the evidence. You've been given a written copy of the instructions I just read to you. You can refer to them during the trial. Since no one can predict the course of a trial, these instructions may change at the end of the trial. And at the close of the trial, I will provide you with a copy of my final instructions for use during your deliberation. Now, my responsibility as the judge is to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of the case, because as jurors, you are the ones who will be deciding this case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and nobody else's. You must think about all the evidence and all the testimony, and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. When it is time for you to decide the case, you are only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you you can consider as evidence. Now, sometimes the lawyers and I are going to have discussions out of your hearing. Also, while you are in the jury room, I may have to take care of other matters that have nothing to do with this case. Pay no attention to those interruptions. You must not discuss the case with anyone, including your family or friends. You must not even discuss it with the other jurors until the time comes for you to decide this case. When it is time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in the jury room and only when all of you are present. When the trial is over, as I've told you before, you can discuss the case with anyone you want. Now, if I call for a recess during the trial, I'll either send you back to the jury room or allow you to leave the courtroom on your own and go about your business. But you must not discuss the case with anyone or let anyone discuss it with you or in your presence. If someone tries to do that, tell him or her to stop. Explain that as a juror, you're not allowed to discuss the case. If he or she continues, leave and report the incident to me as soon as you return to court. You must not talk to the defendant, the lawyers, or the witnesses about anything at all, even if it has nothing to do with the case. And that's what I explained to you yesterday. If they see you in the hallway or on the elevator, they're going to ignore you. They're not trying to be rude, they just can't discuss anything whatsoever with you about the case. Or anything whatsoever in general. It is very important that you only get the information about the case in court when you are acting as a jury when the defendant's lawyers and I are all here. I have previously instructed you that you're not to consider any outside information in this case. The questions the lawyers ask the witnesses are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks questions that assumes or suggests that it is. Now, I may ask some of the witnesses questions myself. These questions are not meant to reflect my opinion about the evidence. If I ask questions, my only reason would be to ask about things that may not have been fully explored. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I will rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the facts of the case. During the trial, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they could give you incorrect or misleading information that might unfairly favor one side. So, to be fair to both sides, you must follow this instruction. You can see that we have chosen a jury of 14 of you. After you have heard all the evidence and my instructions, we will draw lots to see which 2 of you will be dismissed in order to form a jury of 12. I may give you more instructions during the trial, and at the end of the trial, I will give you detailed instructions about the law in this case. You should consider all of my instructions as a connected series. Taken all together, they are the law that you must follow. After all of the evidence has been presented and the lawyers have given their arguments, I will give you detailed instructions about the rules of law that apply to this case. Then you will go to the jury room to decide on your verdict. A verdict in a criminal case has to be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each of you. It is important for you to keep an open mind and not make a decision about anything in the case until you go to the jury room to decide your verdict. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that's direct evidence that it's raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person coming from outside wearing a raincoat covered with small drops of water, that's circumstantial evidence that it's raining. You may consider circumstantial evidence. Circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence, can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by the law. Now, you may take notes, as you're doing right now during the trial if you wish, but you don't have to. If you do take notes, you should be careful that it does not distract you from paying attention to all the evidence. When you go to the jury room to decide on your verdict, you can use your notes to help you remember what happened in the courtroom. If you take notes, don't let anyone except the other jurors see them during deliberation. And your notes will never be examined by anyone. When your service concludes, your notes will be collected and destroyed. Okay? Second Clerk? Thank you.
Your Honor, may we approach?
Yes. One moment, ladies and gentlemen. I need to know by show of hands, have any of you, since this trial began, had any conversation amongst yourselves or others about the case? I don't see any hands. Have any of you read newspapers or watched TV reports about the case since the trial began? I don't see any hands. Did any of you use any type of electronic device to get on the internet, to do independent research about the case, people, places, things, or terminology since the case began? Okay, I don't see any hands. Did any of you read or create any blog, social networking pages, status updates, or tweets about this case? All right, I see no hands. Thank you. Go ahead, counsel.
Thank you. Good morning. This was Renisha McBride before November 2nd, 2013. This was Renisha